Good evening. Thanks for joining us. I'm Richard Gearhart. You're watching a very special edition of KSBY News on Facebook Live. Throughout the Kristin Smart murder trial, we've taken you beyond the headlines with in-depth interviews related to the case. Last week, the trial came to a conclusion, and we learned the fate of the two men accused of being involved in her murder and its alleged cover-up. Tonight, you'll hear from Ruben Flores' attorney Harold Mesick and his time during the trial. First, let's get you up to speed and remind you about those verdicts. A jury found Paul Flores guilty of the first-degree murder of Kristin Smart. The two were students at Cal Poly when Kristin disappeared in 1996 following an off-campus party. Witnesses said Flores was the last person they saw with her that night. Prosecutors maintained that he killed Kristin while trying to rape her. Paul's father, Ruben Flores, was charged as an accessory after the fact. He was accused of helping hide Kristin's body, and a jury found him not guilty. Paul Flores is now awaiting sentencing. That has been scheduled for December 9th. He faces 25 years to life in prison. Well, now that the trial is over, Ruben Flores' attorney Harold Mesick sat down with me for an extensive interview. I spoke with him about the more than 3-month-long trial, and he talked about Ruben's reaction to the verdicts and what it was like inside the courtroom. Here is our conversation. So, first of all, just tell me, surprise, relief at the verdict?
Well, I think I thought all along that Ruben was innocent, not guilty. I was worried when the verdict for Paul came in, obviously, guilty. I'm going, oh man, that's not a good sign. But one of the things that they've told us over the years as a lawyer, that when the jury files in, if they won't look at you and your client, it probably means you're going to be found guilty. So this jury walked in when they first announced the verdict on Monday, remember? Before they actually published it, the jury walked in, and I'm looking at each one of them in the eye, as I did every day when they came in, and they weren't looking at me, and they weren't looking at Ruben. So I was nervous. And then when the verdicts were ready to be announced, when they came in, same thing, they wouldn't look at me. What's up? I didn't have a lot of stress though, because Ruben had served his full sentence by October 14th. So the verdict came in on my birthday, October 17th. So even if he had been found guilty, I believe the judge would have ordered him released because he served his full term. But if you have to wear an ankle monitor, if you're subject to electronic monitoring and your freedom is restricted, as his was, according to some recent case law, you get custody credit as if you're in jail, and you get conduct credit. So he got his actual credit, which was 18 months. And then he got good time credit, which was another 18 months. So that's 36 months, which is his maximum term, 3 years. So that's why I was not stressed, because he wouldn't have been taken into custody. So now I could be wrong on that. The DA was going to argue against it, but the law was pretty clear. So, and I didn't even have to ask the judge to, of course he was found not guilty, but she ordered it removed without being asked. So she was prepared for that.
And when last time I chatted with you was with all the other reporters in front of
Yes.
the courthouse, and you hadn't really had a chance, obviously, at that point to talk to Ruben.
Not
I'm
much.
assuming that you've had a chance to talk to him since then.
Yes, a couple times.
And what is his demeanor like?
Well, he's overjoyed at his own verdict, but he's a dad, and he would have preferred it that he be found guilty and Paul be found not guilty. He believes, as do I, that Paul is not guilty. I believe this is a wrongful conviction. I really do. I believe it was a conviction that was garnered primarily because of emotion. And I'm not faulting Mr. Pavrell, who I have the utmost respect for. I love Chris, in fact. I know him. I know his family a little bit. I wish I knew him better, but no, Ruben's overjoyed at his own outcome, but he wished it were reversed. He wished he would have been found guilty. Of course, he wouldn't have done any time, so it's easy to say that. But yeah, so he's imagine someone close to you is in prison and likely going to face a long term, and you don't believe they've done anything wrong. So that's the position he's in.
Talk to me about that two-jury system. And did you work hand-in-hand with Sanger, or kind of on your own, or how did that go?
It made it all sorts of things a little different. We certainly communicated, but our clients had different interests, So we didn't really collaborate on our defense much. And in fact, during the trial, you'll notice a couple of times Mr. Sanger objected to a few of my questions.
I was actually going to ask you about that because I did notice that.
Yeah, and so the way I looked at it was that if Paul's case was a serious case, Ruben's case was not so serious. He's only facing 3 years, 81. Even if he hadn't been wearing the ankle bracelet, he probably would have only gotten the midterm, which was 2 years. And even then, he probably wouldn't have gotten any real prison time, in my opinion. He's not the kind of guy you send to prison.
So you just deferred to
Yeah,
Sanger?
exactly. So I deferred to Bob. And, you know, Bob's the certainly more senior lawyer. He's done this a lot, twice as long as I have or more. And because his client faced a greater exposure, greater risk, yeah, I would just defer. So.
And I'm assuming this is the first time that's ever happened for your career.
First time I've ever had 2 juries ever. I've had several jury trials, but this whole 2 jury thing, we almost could have avoided it, but Mr. Sanger and Mr. Pavrel, and of course the judge, didn't think it was wise. There's a case, the Aranda Bruton case, where if one co-defendant is not going to be able to be cross-examined and he implicates the other defendant, you have to make allowances for that to give him a fair trial. So that's what they did here. 2 separate juries. It turned out, though, you look back on it, we had one, I think, half day where the juries weren't together, and that was it.
Yeah, and
So you think we could have made, with all the logistical issues around the 2 juries, you'd think we could have overcome that somehow. You know, looking back on it now, I'm obviously glad we had 2 juries, because I think I got the good jury. But, and the other jury was fine, I'm not disparaging the other jury. But I think it added a lot of complexities and logistical nightmares. Just again, you were there every day pretty much. You saw the way the juries had to come in once a week. They're switching them back and forth. Took everything twice as long. Jury questions. We had over 150 jury questions in this trial. I mean, that's phenomenal. You know, in the trials where the judge has allowed it that I've done in the past, you've had 2 or 3. You know, in this one, 150 jury questions. So that means they were paying attention. I like that part, because we wanted jurors who would pay attention, because this was not a case. This was not a case driven by overwhelming evidence. It was not a case driven by, I would say, any evidence. It was a case driven by emotion. And Paul has become a persona non grata in this county for, what, 20-some plus years. I tried to rehumanize him a little bit in my clothes, even though he wasn't my client. He was a 19-year-old kid. He stuttered. Nobody liked him. You know, they picked on him, they made fun of him. I just felt sorry for Paul, so I still do.
Have you had much interaction with Paul at all or not?
No, he's not my client, so I really can't speak to him without the permission of his attorney. And you know, the interactions I had were in the courtroom with him. Good morning, good evening, stay strong, that kind of stuff. Didn't have a lot of discussions with him.
So, and I want to revisit that jury situation again too, because all of the jury questions, plus quite a bit of kind of quibbling amongst the jury themselves, and really questioning the attorneys to a certain extent.
Agreed. Well, as far as the quibbling, I mean, they were turning each other in. Is that what you mean?
Yeah.
Yeah. I mean, again, we started with 12 jurors and 8 alternates, and we lost like 3 alternates in the first week or 2. I forget how it went, but we ended up with only 3 alternates at the very end. So the judge was, again, this judge was on top of everything. She's the one. Chris and I both said, 6 ought to do it. Let's go 8, she said. So we had 8. But yeah, they turned it. Again, to me, that meant that they took their charge seriously, right? They hear this one person talking to another person, and boom, they're telling the bailiffs. So we had a lot of that.
And some really odd things too. Like one of the jurors was even talking to a witness after lunch during testimony.
Right, and that's definitely not allowed. But again, we did the whole. We brought him in. The judge questioned him on the record. That was when they're talking to, was it Dr. Carter? Yeah. What a great guy he was. He was a professor. His first time testifying. That's the kind of expert you want. If we could have experts like him in every trial, we would always get just results. We really would. But that's not the kind of experts we normally get. We normally get experts who their opinion is clearly swayed by who employs them, and that works on both sides. So I love Dr. Carter. I loved our experts, Dr. Carter and Dr. Johnson. I was not impressed with the people's experts.
So I want to get your reaction to a couple of things too. One, there was a lot of talk after the verdicts came out about the jury sort of settling on or viewing the evidence differently. But they were really viewing different parts of the evidence, weren't they?
No, all the evidence was the same for both juries, except for that one little bit where they were separated, and that was the early deposition of Paul. So that's the only little bit that my jury didn't see. But no, the evidence was the same for both of them. That's the weird part.
But I mean, so my question more is, Paul's jury was concentrating on whether or not he was guilty of killing her, and it was more like the house evidence that was affecting Rubens.
Right. My jury still had to reach a conclusion as to whether or not a crime had been committed, and maybe that's where they stopped. We don't know without talking to each of them individually. But maybe in their analysis, they decided no crime was committed, and that's as far as they had to go. They didn't need to reach the 4x6 anomaly and the discolored soil and the alleged blood evidence. They didn't even need to get there if they said no crime was committed. So it would have been the same for Paul, though. If they said no crime was committed, then he would have walked. Paul, in my opinion, Paul's conviction came about as a result of the two Doe witnesses who came forward. And that was conduct after Kristin went missing. So, I don't know. I wish that had not been admitted. But.
And Chris Bavaro was pretty good about walking the jury through that in closing.
I thought so. I thought Chris did a good job with closing with what he had. Again, he had to. No physical evidence in this case, really, none. And that's what's unusual. There's this guy that does manages a website. It's called No Body Trials or No Body something. But he's got all the trials over the last 70 or 80 years where someone has been charged and either convicted or walked when there was no body in a murder case. In almost all of those cases where the person was convicted, there was even though no body, there was otherwise overwhelming physical evidence, like a carpet with the victim's blood stains, or an eyewitness that saw a guy hitting him, even though they don't find the body. We didn't have any of that, remember. And I got slammed for this, but I'm going to repeat it because it's absolutely true. And I apologize to the Smarts if this causes them any grief. I'm a dad, I'm a granddad. There is no evidence today that says Kristin Smart is dead. I mean, there just isn't. So we can all assume that, and I know they've got a death certificate that you get for asking when they haven't appeared for 5 years or however it works. But we don't know that she's dead, and that's the importance of a body. We don't have it. So, and then because we don't have this other overwhelming physical evidence, like if they had found, like I said in my closing argument, if that blood had been able to have been, the DNA, if the alleged blood had been able to have been tied to Kristin Smart, game over. That would have been it. But it wasn't. First of all, I don't even think it's blood. The test they used was invalid. And then the minuscule pieces of fibers that were introduced, the state's own expert said she can attach no significance to that, right? And they could have gone out. FBI has a great lab where they can find those fibers. They can trace that fiber to wherever its source was. People didn't do that. I don't know why they didn't do that. Actually, I do know why they didn't do that, but they didn't do it. That's the most important part. So the trace evidence was not evidence. It's just detritus. It's stuff from a construction site. I worked construction, I was a fireman and a building inspector and built a few houses. All sorts of stuff happens on a construction site. And if somebody cut their finger 30 years ago and bled a little bit and it got into the soil, I mean, you were there for the testimony of Shelby Liddell. I think it was Shelby, or was it Angela Butler? Well, I forget who it was. One of them had to pick through with a stereo microscope and tweezers. It must have been Butler, Angela Butler, to find what she thought was suspicious, looked like blood. Looked like blood. Well, then she puts it into this test that specifically says don't use this test if it's been exposed to soil for more than 4 weeks. And they used the test anyway. So they got a positive result. Still, it's still not evidence, right? It's just supposed blood. Could have been ferret blood, could have been higher primate blood. It could have not been blood, which is what our position was. It just wasn't blood. You're just getting a false reading. In fact, they got more false readings than positive readings in all the same tests from the same discolored soil. So, but 21st century, you know, CSI, what's the other one I liked? I don't like CSI actually. I like the one with Mark Harmon. What's that one? NCIS.
Yeah.
That's a good one, you know. There's always this forensic scientist, right, who solves the case because, you know, this kind of bug only lives here and that kind of soil. We had none of that. What we had was a bunch of speculation. And what we had was the most obvious suspect. And we had a community that's screaming for justice. And you were there every day. You saw the one side of the courtroom that would get filled. And a little mini industry has arisen around this case, you know. Chris Lambert, who I think is a fine young man, he's one of my son's age. I mean, he's developed a whole, you know, I don't know, you got to interview him. What's he doing now? What's he going to do? He's got to be finding a book deal or something, or a movie deal.
Yeah, he didn't.
Right?
He didn't tell me, but yeah.
No, he's got to be doing something.
He's dedicated his entire life to this.
Yeah, and more power to him. And you know, I have a lot of friends who are into these true crime and cold cases. I get it, but yeah.
So the other thing I wanted to that people are making something of is how quiet you were in court. I mean, you didn't have to say a lot. Was that a strategy of yours, or is that how it played out?
Well, partly with our Paul, greater risk, greater exposure. Ruben, especially when I found the case where he looks like he's going to walk regardless of the verdict. If the witnesses were strictly against Paul, I'd laid back. Unless there was a really, like I could have gone harder on a few of the witnesses like I did at the prelim, specifically Jennifer Hudson, and who was another one? I went kind of hard on, what's his name? Phillips. Early on, the guy who claimed to have been a friend of Kristin's, the basketball player.
Oh, yeah.
Can't remember his last name right now. Went kind of hard on him, but that's because he wasn't being truthful. And I just can't stand that. So, but I backed off on Jennifer. I backed off on Dustin Goodwin. I backed off on most of the people at the party, you know, because they weren't really directly affecting Ruben. So the people I felt that was most important to cross-examine for my client were the state's experts. And yeah, so I guess it worked out well. So.
And you were always at the end. That was by design because of the charges, or?
That's just the way we worked it. And I would, if Bob walked in here now, I have utmost respect for Mr. Sanger. I would defer to him almost for anything if it comes to a legal question or this or that. I mean, he's done it longer. So I was in the Army. I believe in a chain of command and all that stuff. We didn't work that out formally. There was one time when I went first. There was a reason for it. I forget why. But mostly, yeah. Bob went first. I went second.
And that's, I mean, you guys worked out amongst yourselves, not necessarily.
That's the way we started it in the prelim, and we continued it in the trial, and there was never any sort of formal rule. I could have asked at a couple points, can I go first? But what's the point? I'd always rather go second.
So viewers would challenge that in the sense that why didn't they cooperate more with authorities at the very beginning?
Well, you know, you have the Fifth Amendment right to remain silent. And whenever I get a client, what's the first thing I tell them? Don't talk to anybody. Don't talk to anybody except your wife or your husband or your lawyer, because those are the only privileges that are going to be maintained. And when you say something, you know, the warning is very explicit, the Miranda warning. What you say can and will be used against you. We go to law school and learn how to turn people's words around, right? And even if you say something absolutely innocent, under the right circumstances, I'm going to make it look like you're guilty as sin. So the best advice, and this was good advice that Mel de la Motte gave to Paul early on, don't answer any questions. You have the right to remain silent. You know, the joke amongst us criminal defense attorneys is you have the right to remain silent, but rarely do you have the ability. Most everybody wants to talk, right? You always think, if I just tell them what happened, they're going to let me go. Nope, they're just going to mark that down for later and see if we can use it against you. So the advice is always remain silent if it's a criminal matter. And this was clearly a criminal matter. They were deposing him and interviewing him because they believed he had killed Kristin. So no, people are just, the people who say that have never been in the position of being threatened with the loss of their freedom, right?
Let me pose some questions to you too
Sure.
that I've gotten from viewers.
Good.
One is the financial aspect of it. I mean, who pays for all this and what does it cost?
Well, I probably can't comment real directly on that, but I was privately retained. Mr. Sanger was privately retained. Mr. Sanger runs a huge operation. He's got a very high overhead. He put in tons of work on this case, tons and tons, hours and hours and hours. Luckily, they had some assets, you know, or have some assets that were able to, you know, cover the fees in some sense, but I probably should stay away from that one.
And then will you still be involved in a subsequent civil case if there is one or not?
At the moment, I represent Ruben. I hope to continue to represent him. I think he's a fine gentleman, like I said, in court and out of court. He's a kind, generous man. He really is. He's been portrayed as this, I mean, people look at his picture and, you know, they just, I don't understand this. I really don't. How people can draw such strong opinions on such weak evidence, like a picture of a person, you know? Ellen, look at that smile on her. She's probably a real piece of work, right? I mean, I don't know Ellen. I'd like to meet Ellen, but I'm not going to draw my opinion. I'm not going to conclude anything about her from a picture. But you see that all being done on the internet with Ruben, you know? Oh, he looks like an abuser. Oh, you know, the apple doesn't fall far from the tree. Paul must have been abused as a child. That's just a bunch of crap. And that's from these people. They're not trolls. I don't know what you call these people on the internet who are so quick with their opinions with the littlest, the smidgen of understanding or evidence. They just lash out. I still don't understand it. So I know they're pissed about Kristin. I know they think he did it. But I don't know.
Anything else?
I'm not raising my kids that way.
Anything else you think our viewers need to know about the case that they haven't heard in the media or from the court producer?
There's a bunch I would like to say, but I'm handcuffed. Yeah. I'm proscribed. I'm prevented, and that's wise. I mean, I will say this. I do want to say, Judge O'Keefe was fantastic. She really was. She's the kind of judge if we had judges like her, and we had experts like Carter, and we had juries like we had there that are just, I even said this, I don't know if I ever said it to my jury in the closing argument or not. I had planned to say it, I might have skipped over it. But when you get juries like this who are so involved, it might be better just to let them ask the questions, right? Why make the lawyers do it? You got 12 people up there, they all have questions. Let's let them submit their questions. Sometimes that might, lead to a better result. I don't know, but what do I want them to know? Now, I would like people to honor the presumption of innocence is so important. It really is. But that was never present in this case. In this case, Paul has been guilty from day one, especially to the internet, the Facebook posse, we call them. And I understand why they want to feel that way. I understand why they feel that way, but they're just wrong about it. They're just wrong. And at some point, you know, it's going to get me in trouble too, but I would love for Kristin just to reappear somewhere. I would be overjoyed at that, obviously, that she's alive, and you know, maybe she got hit on the head and been walking around with amnesia for 26 years. I don't know. But I would love that kind of vindication, you know. Another quick thing, if I could just correct this for the record too. There was never, ever any discussions about a plea agreement with Paul Flores and the district attorney. Never. That is completely, just completely out of left field. So people are using that on the internet. Well, he talked about getting a better deal if he took him to the body. You know, if my client knew where there was a body, you guys would know it. I guarantee that. We don't know there's a body because we weren't involved in any sort of murder or obstruction or hiding. So, again, the simple answer is often the best. In this case, they don't know where the body is. That's why we're not coming forward with it. So,
we want to thank you for joining us for this special broadcast, and thanks again to my guest, Harold Mesick. And of course, you can find all of our coverage of the Kristin Smart case on our website, KSBY.com. Use your phone to scan this QR code, and it will take you straight there. Thanks again for joining me tonight, and we will see you next time.